Director of Law and Assistant Prosecutor for the City of Shaker Heights. And one of my additional responsibilities that I do for the city is that I am the administrator of the Fair Housing Review Board. So on behalf of the City of Shaker Heights and the Fair Housing Review Board, I would like to welcome you here this morning. What I'd like to do this morning, you hopefully all have an agenda in front of you, is start off with a few introductions. There are some people present here today who have made this seminar possible, and I'd like to introduce them. First of all, I'd like to introduce Cheryl King-Benford. She is the Director of Law for the City of Shaker Heights, and she would like to address you this morning.
Good morning, and welcome again to our Fair Housing Seminar. This is the way we celebrate Fair Housing Month in Shaker. We attempt to do educational programs, and this one it's especially good to do because many of you are landlords here in the city of Shaker Heights, and we believe education in fair housing is important. It's good business. It is what you need to know and what we need to know. We need to know that you know to make your business of providing housing in Shaker Heights a good one. I'd like to thank you all for coming. I'd like to welcome you on behalf of Mayor Mearns, who was here earlier and had to leave for a Planning Commission meeting. I'd like to thank Lisa Gale, Bill Edwards, and from our staff, Mary Murphy, for the hard work that went into putting this seminar together and producing a Landlord's Guide to Fair Housing that you have at your places. We want you to take this home. This will be teaching material today, but it also sets out key information about the fair housing law that every provider of housing should know. We here in Shaker Heights have been involved in fair housing for a very long time, and we in the law department, in fact, enforce the fair housing law, and Lisa will tell you more about that later. Complaints of discrimination are made to us, and we investigate them and resolve them. But many people don't realize that the fair housing law also encourages affirmative marketing. And the arm of my two departments, I have two now, the law department and pro-integrative services, is our affirmative marketing arm. And I'd also like to introduce in the back Diana Vargo, who is the manager of pro-integrative housing, and Judy Steeler, who many of you landlords know because she assists you in working with your property to make it more marketable. Thank you again for coming, and I'd like to turn the program over to Lisa and say I'll be leaving you too to go to that special planning meeting that's taking place at City Hall, but I'm sure you're going to have a wonderful morning. In case you're wondering why we're filming, we participate in training providers of housing and fair housing throughout the year. So this tape will be for them. Don't look for yourselves on Cablevision because you won't be there. Have a good morning.
Next, I'd like to introduce Stephanie Turner. She is a councilwoman with the City of Shaker Heights, and she's the chairperson of our Fair Housing Review Board. And also, while Ms. Turner is making her way up, I'd like Mr. Williams, James Williams, to stand in the back. Mr. Williams is a member of our Fair Housing Review Board and came to attend today's training. Ms. Turner.
Thanks, Lisa. Again, I'd like to welcome you on behalf of Shaker Heights City Council and also as chairwoman for the Fair Housing Review Board. And I just want to say briefly that you are going to find that this is outstanding training. I mean, we have the best right here, Bill Edwards and Lisa Gale. They'll tell you all you need to know about fair housing. I've been so impressed with their work. But also, as Cheryl has mentioned, I'd like to thank Mary Murphy for all of her hard work in supporting all of us. And again, thanks. And you'll find that this is going to be very valuable to you.
Now, you've heard her name mentioned twice now, so I'd like Mary Murphy, if she wouldn't mind, in the back to stand. Mary is a legal secretary for the law department, and she's also our intake agent in the Fair Housing Department. So I'd like to thank Mary, because without it, we wouldn't all be here today. So thank you, Mary. What I'd like to go through real quickly are the handouts that you have in front of you, so you know what we're going to be referring to at different times. First is the Landlord's Guide to Fair Housing Manual, which is something that just is hot off the presses, actually. It's been a few months in development by our office, and hopefully it's going to be of great assistance to you and serve as a reference manual for you. And we're going to use parts of this morning. You will also have at your place something that's called Translating Theory into Practice, Motivating and Educating Employees in the Fair Housing Context. This is actually the PowerPoint presentation that's going to be done by Bill Edwards, so you'll have a copy of that to take home with you. Also in your packet you have something that's entitled Chapter 515, Fair Housing. Looks like this. This is a copy of the City of Shaker Heights Fair Housing Ordinance, and so I would ask you to, in your spare time, to take a moment and go through this ordinance. We're going to cover the basics of it today, but it's important, especially as landlords, that you know the intricacies of our Fair Housing Ordinance. And lastly, we've included in your packet a copy of the Fair Housing Act itself. This would be the Federal Fair Housing Act. And you will also have this as a reference. One of the first things that I'd like to do is give you an introduction into our program and why we're here. In 1992, the City of Shaker Heights applied for something which was called substantial equivalency. And what that meant is that our Fair Housing Ordinance we submitted to the U.S. Department of Housing and Urban Development. And they reviewed our ordinance to determine if our ordinance was substantially equivalent to the Federal Fair Housing Act, meaning did we protect the same things under our law that the federal government aimed to protect under the Federal Fair Housing Act. And in 1992, HUD granted us substantial equivalency. And the result of that was that it enabled us to act as a little arm of HUD right here in Shaker Heights, so that if people have fair housing complaints, instead of sending them to downtown or sending them to the Ohio Civil Rights Commission, they can come directly into our office in the law department. And they'll meet with Mary Murphy, who will do the intake of their complaint. The complaint will be investigated by Bill Edwards, who I will introduce in a few moments. And it will be under the jurisdiction of our Fair Housing Review Board. So what this substantial equivalency designation allowed us to do was to set up in Shaker Heights the ability to regulate our fair housing and the ability to not only try and do training and education, but also in those times where maybe more than training and education is needed, to have the authority to do that as well. Besides the, I guess some would refer to that as the stick approach to fair housing, you know, the prosecution, the enforcement end. What I also like to think that came about as a result of the substantial equivalency was the carrot approach. And what we've been doing when we were given this substantial equivalency is we were also given some grant funding. And what we've tried to do with that grant funding is we have tried to make sure that we do educational programs such as this. I don't know how many of you were here 2 years ago. We did a similar program for landlords to give you an opportunity, give you an introduction to the fair housing law, try to tell you what some of the tricky parts of it are, where hopefully we can help you watch out for pitfalls and traps, and to answer some of your questions so that you would not find yourself on the other end of a fair housing complaint. Some of the other things we've done with the money is the manual that you have in front of you. This was a special grant from HUD that was given to us to develop this. We have instituted in the high school a fair housing curriculum. What happened was when we originally got this grant money is we met with the chairperson of the history department for the high school. And what we did is we sat down with them and we developed a 1-week fair housing curriculum that would be taught in the senior government classes and in the junior American history classes, so that every child who went through Shaker School would have a 2-week introduction into fair housing. And that's something we're very proud of, and hopefully the high school students have enjoyed that section. The teachers have worked very well with us in continuing that tradition. Some of the other things we've done is in 1994, we had Julian Bond come in and speak. I don't know if any of you were lucky enough to attend his lecture. He is well known for his fair housing efforts and his efforts in civil rights movements, and we were lucky enough to be able to bring him in to talk to us. We have produced a fair housing your rights under fair housing brochure, which I'm sure some of you have seen because we've tried to flood Shaker Heights with them. It's a little green brochure that basically walks through people what their fair housing rights are. So the goal of this program is not only to provide the stick approach, as I said, but also the carrot, like we're doing today. What I'd like to do and how I'm going to start out is I'm going to walk you through how our Shaker Heights fair housing process works. So you understand, just in case you do find yourself on the other end of a fair housing complaint, what the process is, so there's not going to be any surprises to you. And then after that, I'm going to turn it over to Bill Edwards, who's going to walk through and tell you how not to find yourself on that side, okay? I'm going to refer to the manual that you have in front of you. You'll see that there's a section in there, the tab that says Complaints. So if you wouldn't mind turning to that tab. All right, let's take a scenario. There is a mother with a young child, and she sees an advertisement in a paper for a two-bedroom apartment here in Shaker Heights. And she goes over to apply for this two-bedroom apartment, and she has a good, steady job, and she's got good credit, and she's got a pretty good rental history. And when she goes to the landlord to submit her application for this, she's told pretty straightforward that, I'm sorry, ma'am, but you know, this is a very quiet building. Our tenants really come here because we're known for being a very quiet building, and we'd really prefer that we did not have children. All right? And you'd be surprised. There are some people that still feel that they have the ability as a landlord to do that, which we all know in 1988 changed with the familial status protection. But what would happen is, if that woman understood that that was a violation of the Fair Housing Act, she could do one of two things. Actually, one of three things. She could call our office in the law department to make an appointment to come in. She could go down to the Ohio Civil Rights Commission, which has a local office downtown, which also handles fair housing complaints. Or she could go directly to the office downtown for the U.S. Department of Housing and Urban Development, the HUD office. If she went down to the Ohio Civil Rights Commission and filed her complaint, what would happen is it would be turned over to our department. If she went directly to the HUD office downtown and filed her complaint, it would also be turned over directly to our office. We have sole jurisdiction for things that happen in Shaker Heights, so it would come back to my office to investigate. What happens is she would come in, she would meet with Ms. Murphy, and Ms. Murphy would ask her to walk through exactly what her side of the occasion was, what her side of what happened was. She would fill out what's called a 903 complaint, which some of you may or may not have seen. It's a form that basically sets forth what her allegations are and on what basis she felt that she was being discriminated against. And then what would happen is that information would be turned over to Bill Edwards. Bill is our fair housing investigator and does all of our investigations for the city of Shaker Heights. When Bill gets notified of this, you would also get a copy of it. If you were the landlord that was being alleged to have committed this violation, you get a copy of the 903, so you get to see what the allegations are. And you'd be receiving a letter from my office saying that you should get in touch with Mr. Edwards as soon as possible, so that the two of you could sit down and he could get your side of what happened. What happens then is, under the law, under our ordinance, we have 100 days to complete our investigation. And during that time, you'll probably be seeing a lot of Bill. He's going to want to take a look at some of your records. He's going to want to come over and take a look around your building so that he can be familiar with your surroundings and exactly, if there's an issue about a playground or, how many units in a building, he can actually walk through and get that information for himself. And he'll ask you to walk through with him so that you can help him understand the layout of your building or of your home. After that, after Bill conducts his investigation, what he does is he submits to me a written report. And I wish I brought a copy of the last one we did because it was about 3 inches thick. So it's a thorough report. It's a thorough job. What's contained in there? Well, what's contained is the complainant's version of what happened, the respondent's, which is the landlord's version of what happened, or the property owner or property manager's version of what happened. If there were any witnesses to that event, then they would be interviewed by Mr. Edwards and their version would be contained in his report. He would also attach all the documentation if he got a list of your tenants or your what your vacancy list looked like for the past 6 months. All of that information would be included in his report. And what I do, what my job is to review that report and determine, after looking at all the evidence, whether or not I believe that a violation of our ordinance has occurred. Now, one of two things can happen. I can look at that and say, you know what, maybe it was just a miscommunication. I don't think that there was any violation of the law. Probably it looks like what we're talking about here is a misunderstanding. And what I would do then is I would issue what's called a no probable cause, meaning that there's no probable cause or reason to believe that a violation of our fair housing ordinance occurred. And once I do that, the complainant, who is the person who originally made the allegation, they have the right to appeal my decision. They could say, no, Ms. Gale, I'm sorry, I disagree with you. I think that there was a violation. And if they do that, then what they do is they get to meet our Fair Housing Review Board. And our Fair Housing Review Board then becomes kind of like our little appellate court here in Shaker Heights. We would come in, we would do a hearing, and the Fair Housing Review Board would decide whether or not to uphold my decision that there was no basis for the complaint. If, on the other hand, let's say that I do review the evidence and I think, you know what, I do think that there was a violation of our ordinance. What I'll do is I'll pull the respondent and the complainant together, and we'll see if we can come up with some sort of settlement. I have 60 days under our ordinance to reach what's called a conciliation or a settlement agreement between the parties. If I can conciliate or settle this matter, then it's considered settled and closed, as far as I'm concerned and as far as HUD is concerned. If we are unable to conciliate the matter, then once again it goes in front of our Fair Housing Review Board. So that I don't want you to think that I'm the last step in the process. There is we have, like I said, our Fair Housing Review Board acts almost like a mini court, and they have the authority, after listening to all the evidence, to decide which way they think is best, whether or not there was a violation or whether or not there wasn't. If they decide that there was a violation, then they have the right to issue against the landlord under our ordinance monetary fines, injunctive relief saying that, you know what, you're going to have to hold this apartment open for that complainant so that they can move in there. They can require you to go to fair housing training, such as something like this. Or they have a wealth of other penalties available to them. So what we try to set in place is a fair, thorough investigative system. I'm very glad to say that we're not too busy during the year. I would say since 1992, maybe we average, 2 or 3 a year? Only 2 or 3 complaints a year we average, since we've been doing this for almost 6 years now. So I like to think it's because we're out there doing the carrot approach, that we're out there educating landlords, we're educating tenants, we're educating property owners on how to not get into these situations. And so I think Bill should take a lot of credit for that. I think I'm going to take some credit for that. And that is the reason why we're not that busy on the other end in our stick approach. What I'd like to do now is I'm going to introduce and turn this over to Bill Edwards. Bill and I have known each other for a long time. We went to law school together. And he has been, in his early part of his career, he was on his own. He was a sole practitioner doing civil rights and fair housing litigation on the plaintiff's side. He has done numerous training seminars for national organizations in fair housing, for landlords and associations, on how not to get into trouble under the fair housing law. He recently, as of this year, has been affiliated with Ulmer & Byrne and is currently in their employment and labor litigation department, and also handles fair housing complaints both on the plaintiff and defense side now. And most importantly to me, he's my investigator, and has done a very good job for us for the past 6 years now. So I'm going to turn it over to him, and we are going to be at this point in time working on the PowerPoint presentation.
Good morning, everybody. Can everyone hear me okay? In the back? Okay. It's a pleasure to be here. I want to say a few comments before I begin about the city of Shaker Heights. For those of you who are residents, you really ought to be very proud of the program that we have. And I say that not because I'm a resident of Shaker. I say that based on observation and experience. And let me give you an example. Periodically, the city of Shaker Heights sends me to training sessions where I have to be certified as a HUD trainer, or investigator, I should say. And in that process, I get to meet people from all over the country. I get to meet representatives from different state agencies who do the same thing that we do here at the City of Shaker Heights, who are also substantially equivalent. And what I've noticed in the last 5 or 6 years of going through these different trainings is that we get a lot of respect at the City of Shaker Heights. When people see my name tag, it's not Bill Edwards they're reacting to, believe me. It's the City of Shaker Heights. They want to know more about our program, how we've been able to make this a real success. And, you know, the other thing that I want to emphasize is that while Lisa has described, the complaint process and how, you may be a respondent at some point in time, you should also know that the law department is your resource. If you have a question about a fair housing matter, you should feel free to call the law department. And that's why their phone number's listed in the beginning of the Fair Housing Guide that's been provided to you today at 491-1440. It's not just for alleged victims, it's also for housing providers because, a couple years ago I remember listening to Judge William Corrigan speak, who is he's a former housing court judge in the city of Cleveland. And what he said when he addressed a group of housing providers is that the first thing out of his mouth was, I want to thank you because you provide a tremendous service to so many people in the community. You provide a home, a roof, somewhere to live, somewhere to make a life, and that goes unnoticed. Here at the city, we're not interested in us versus them. We're all part of the same team here. So if you have questions, whether they be, during the course of an investigation, or whether they be because you just aren't sure about what you should do, you should call the city. Now, they may refer you to a private counsel, but more often than not, they're going to answer your question, particularly if it has something to do with the local ordinance. It helps me to get a feel for my audience, who I'm addressing. I know some of the people here very well. Some of you I've never met before, and I was wondering how many people do we have here that own or manage more than one building? If I could just get a show of hands. I'm going to raise them high so I can see. How many people here operate single-family homes where they rent out part of their own house and they own no other property? Two-family? Okay, good. I'm getting a better feel for this. Okay, good. We've got a diverse group today. Lisa, could I have some water, maybe? Yeah, forgive me, I'm getting over a cold. And as I was lying on my back on Wednesday morning, thinking to myself, great. Not only do I have to give a speech on Saturday, but I'm going to be on TV. So we're going to make this just fine. We've got a really nice PowerPoint presentation that I think you will find that is effective. We've provided you copies of the federal statute and the local ordinance for a reason. Whether you own a single-family home and you're renting that out, part of that property out so that you can have some additional income, whether you own multiple properties in different states, the fact of the matter is you are conducting a business. And because you are conducting a business, you need to know what the law is. You need to know when you cannot say certain things. And I do this more as an approach of an informative standpoint, but what I find and what I've found in the process of prosecuting fair housing claims, defending fair housing claims, and investigating fair housing claims is this one common truth. The number of people that are out there that intentionally get up out of their bed in the morning and say, okay, I'm ready to be a racist. I'm going to discriminate today. They are outnumbered by the number of people that are out there that don't have a system for leasing units. They don't necessarily mean to hurt anyone, but they don't know how to run a business. And what happens is, because you're not organized, and organization is the key to any successful business venture, because you're not organized, you start to make mistakes. And what I'm going to do is I'm going to make this presentation from the standpoint of someone who owns more than one property, but it really does apply to anyone, whether you own two-family homes or whether you own just a single-family home. Commonly, you have a problem that will come up, and what's that problem? The problem is that the person who is kind of managing the store, she's the frontline part-time leasing agent. She doesn't like her job. Maybe you don't have a part-time frontline leasing agent. Maybe you're running a business on the side, but you've got other things as well. This is just a matter of you trying to get extra income. Maybe you're the owner of a single-family home. Whatever it is, if it's not your main focus, there's a concern. It's a red flag right away. But for the part-time frontline leasing agent, you know, I don't know how many of you have this situation where, pardon me, you have an individual who works in an office with no windows, lives in that apartment building as part of their wage, and gets up every morning and wishes they could be somewhere else. So they've got a bad attitude to begin with. Well, as time goes on, the part-time leasing agent, because she has no system, no organization for leasing units, she has no apartment availability sheet, she has no way of keeping track of what's available, what is not, she has no standard for determining whether someone is qualified. What she does is, after a while, because this happens with all of us, she gets overwhelmed. How do you get overwhelmed? Well, I don't know if it's like this for you in your business, but in my business, we never get a steady stream of work. What happens is you get 3 or 4 cases that come in all at the same time. And if you don't have a system for processing those cases, for divvying out the work, you are overwhelmed. You really don't have any way of dealing with the problems, the business challenges that you need to address. And when you don't have a system to work within, and when you don't follow a system, because it's not enough just to have the system, you need to follow it as well. But when you don't have that system and when you don't follow it, and you get overwhelmed periodically, this is what happens. Your subjective evaluations influence the decisions when no system exists. And what do I mean by that? I'll give you a good example. Most of the cases that I handle do not involve direct evidence of discrimination. For those of you who are curious as to whether I think, bigots and racists are still out there in the rental market, absolutely. But as I said, they're few and far between compared to business people who don't have any system for organization. And when you don't, what will happen is a situation like this. Tenant A, or potential tenant A, comes to apply for your place of residence. This person happens to be African American. All right? At the same time, you have 3 or 4 people that are waiting to be served. And you're hustling. You're trying to work. You've got an available unit, whether it be at a multi-unit complex or whether it be part of your 2-family home. And at this time, you show tenant A, potential tenant A, certain aspects of the property. Perhaps you show them some of the accommodations, but you don't have time to show them everything. You don't have time to show them everything because you've got other people that are waiting for you, other potential tenants that you want to make sure, get a chance to take a look at the property. Potential tenant A comes and goes. 15 minutes later, another individual comes and visits your property. That's potential tenant B. And potential tenant B now, she gets the full treatment, not necessarily because you're, judging her in a better light because she's white, but you know what? You don't have 3 people that are waiting anymore. Everything's kind of calmed down. Things are a little smoother. You've got more time. You've got no system, but you've got more time. You've got no objective checklist to go through that's going to indicate what things you need to show to everyone each and every time someone comes through your door. But now, because potential tenant B is here and the luxury of time has come upon you, you can now show her the place that you want to show like you'd like to show everyone. You know what? Unfortunately, potential tenant A and potential tenant B are testers from the Cuyahoga plan. They weren't interested in renting your unit at all. But you know what they were interested in seeing? They were interested in seeing whether or not you treated everybody the same. What happens next? Well, you have a fair housing complaint that's filed against you with the city of Shaker Heights. And by the way, just to elaborate on what Lisa said, not only can an individual file an administrative complaint with either the City of Shaker Heights, HUD, or the Ohio Civil Rights Commission if they believe they've been had their rights violated. They also can go directly to court, either in federal court or in state court. And for those of you that like to know what the statute of limitations are, to file an administrative complaint, you have 1 year from the date of discrimination to file that administrative complaint. To file a federal complaint or a state complaint, you have 2 years, whether it be per the Federal Fair Housing Act or whether it be per the Ohio Fair Housing Act. But back to our little scenario, which I'm making up as I go along. I'm not really making it up because I've seen it happen too often. Now you've got this complaint that's come forward. And you are now what's called a respondent. A respondent that may potentially have to appear before the Shaker Heights Fair Housing Review Board. And I am the investigator. And I've interviewed the complainant, who was an individual who on one day visited you, and you told them that there was nothing available, and that you would talk to them later, if in fact, you thought there was something available. And that tenant had a bad feeling, this person had a bad feeling. So she actually contacted the Cuyahoga Plan, who worked through us, and we tested the building, and in fact, this is what we found. What am I going to look for as the investigator? What am I going to be curious about? I'll tell you what I'm going to look for. The first thing I'm going to ask you is, do you have a policy that prohibits unlawful housing discrimination? No. No, I don't. I'm just renting out a 2-family home. I just got a little overwhelmed here. I see. And then I'm going to want to know what the rental history is of your units. I want to know what the race is of the people that live on your units. I'm going to want to know certain things about, well, do you have a system for providing information to each potential applicant that comes your way? What's your criteria for turning people down? If you don't have those kind of things in place right now, if you're just starting out, you got to think about that. We're going to go into more detail, because what happens is I'm going to start to say, well, we've got a problem here, property owner X, and I want to deal with this the right way, and I want to try to conciliate this matter if I can, because, really that was the whole purpose behind the Shaker Heights Substantial Equivalency Program, to give complainants and defendants another forum to resolve disputes that would avoid having to go into court and to incur substantial litigation expenses. But I got to tell you something. You've got a real issue here. And what's the issue? The issue is that while there's no direct evidence of discrimination, you treated 2 people that were similarly situated differently. And the only difference between these 2 similarly situated potential tenants, the only difference is their race. Your defense, well, I just got overwhelmed, it's not going to cut it. And if you get somebody who says, you know what, I don't like this Shaker Heights process, I think I'm going to go get a private attorney, it could cost you and your business a lot of money. Not necessarily in paying damages to, a complainant, but I'll tell you right now, it will cost you a lot of money in paying your attorney to defend you. And I wouldn't really wish that on anybody, including my own clients who are sitting here today. So, having said that, let's talk about what I mean when I discuss, Charles, there we go. The result, when you have disparate treatment. Now, can all of you see this? Okay. Let me tell you what it says, and maybe we'll get the lights changed so that we can have that altered. Normally, 90% of the cases that involve fair housing litigation claims involve what's called disparate treatment analysis. And that means simply this. You do not have direct evidence of unlawful discrimination. The days are gone. They've passed us by where people said, I'm sorry, I don't rent to black people. You don't have a slam door in the face anymore. Instead, it's what I call a revolving door. It's where, simple things are offered to one potential applicant and not offered to another, as a means of providing a chilling effect, the argument goes, to a set of people versus another. An example? Well, I tell all of my black applicants that I've got real stringent credit standards and that it's a double security deposit if you come visit the property. But I don't offer the same information to white applicants who visit my property. I don't show the black applicants the recreation room, the laundry facilities. I don't show them those things that I offer to all my current tenants, even though I show them to my white tenants. Now, you can see where if you were overwhelmed in a situation, if you didn't have a system where you had a checklist of everything that you were to provide, that you could make a mistake. Not necessarily because of the race of the potential applicant, but the argument goes you could make the mistake because of the fact that you just don't have the time, and you don't have any way of making sure that everyone is afforded the same information and provided the same information. When you don't have direct evidence, and you file a complaint in U.S. District Court or you file a complaint with the Shaker Heights Review Board, the analysis is the same. There was a case in 1973 that was decided by the Supreme Court of the United States. It was called McDonnell Douglas versus Green. It did not deal with Title VIII, which is the Fair Housing Act. It dealt with Title VII, which is the Civil Rights Act of 1964, which actually prohibits unlawful discrimination on the basis of a number of categories in the workplace. But the analysis is the same. What's the analysis? And you need to know this, not because I'm training you to be a lawyer. You need to know this because if you're going to be an effective housing provider, and if you're going to be able to recognize red flags as they come your way, you've got to know basic legal principles of the Fair Housing Act. And this is one of the basic ones. I come forward with what's called my prima facie case. Nice Latin term, means on its face. And I state my claim as the plaintiff. And the claim is simply this in our example. I'm a member of a protected class. I'm an African American. I was qualified, willing, ready, and able to rent the apartment that was displayed for rent in the ad that I appeared on. And as a result, I was turned away, and the reason I was turned away was because of my race. Now, that's the prima facie case. All that does is it gets you in the door as a plaintiff. But ultimately, the burden then shifts to you. And you have to provide a non-discriminatory reason for the action that you took. Now remember, you can't say I was simply overwhelmed. I guess you could, but now we've got evidence that you treat two sets of people differently, even though they applied on the same day 15 minutes apart. So you come up with your non-discriminatory reason, whatever that might be, and then ultimately the burden will shift back to the tenant, back to the plaintiff. And she or he must show that the reasons that you set forth are not the true reasons that you failed to rent to that individual, that they are pretext for discrimination. Okay? We have this shift. Now, when you don't have the right systems in place, you don't just have disparate treatment of applicants. You have disparate treatment of employees at times. You have disparate treatment of guests. And the list can go on. Ultimately, the disparate treatment will result in several things. And I'm having trouble with this, Charles. Here we go. Number one, for those of you who can't read this because of the lights, you're going to have a substandard product. I think that's clear. If you're running a business and you want to make sure that you have 100% rental occupancy, you're going to have difficulty doing that if you don't even know what's available. One tip that I would pass on to all of you is that you should have apartment availability sheets every day listed for those of you who have more than one unit. What do I mean by apartment availability sheets? I don't want to go into too much detail about this because I want to get into the substantive portions of the Act, but apartment availability sheets simply should state at the end of each business day, what apartments were rented, what apartments are not rented. When someone applies for an apartment and submits a formal application to you, you should have a policy that defines whether or not that apartment is now on the market or off the market. Why? Because you're going to get into arguments sometimes down the line whether or not someone has actually applied for an apartment that is available. And the word available means a lot here. So you should have that system in place if, in fact, you have more than one unit. Now, for those of you that are sitting back saying, gosh, none of this applies to me. I have a single-family home or I have a two-family home. We're going to get to everything that applies to you very soon. And one of the things that I know that you're very interested in is, well, can I turn away families with children since the Mrs. Murphy exemption applies to me? Well, we'll get into that, and the answer is no. Okay. Quickly, when you have employees that you are looking to motivate, when you have a disparate treatment with no system, it results in poor morale. And when you have poor morale, you're going to lose business, which means you're going to lose profits. And when you lose business and lose profits and you have poor morale and no system, ultimately you're going to have potential lawsuits and charges of discrimination, which means legal fees. So that's the problem. What's the solution? Well, the first thing that you need to do is you need to educate yourself and you need to educate your employees, if you have employees, about what the law says. If you don't do that, you're not going to be able to recognize the problem areas as they come along. So let's talk about what the law says. You have actually 5 laws, not 1, 5 that apply to fair housing. Obviously, we have, and I think it's appropriate that we're here on the 30th anniversary. 30 years ago, the Fair Housing Act was made into law. But the Federal Fair Housing Act has been on the books since April 11th, 1968. That's law number 1. Law number 2 is the State Fair Housing Act, which is Ohio Revised Code Section 4112.02H. Law number 3 is the Shaker Heights Fair Housing Ordinance, which is Section 515. If you look at in your local business section, you should have a copy of that. That should be placed, if you ask me, 3-ring notebook, just like this one. Punch it 3 holes, and you put it in there. You should have a copy of that law with your records. If you don't have a copy of the law with your records, you should ask yourself how you're conducting your business. You need to know as much information as possible about what the law says. Otherwise, you can't make informed decisions about your business. Now, in addition to the 3 substantive areas, we also have 2 laws that were passed shortly after the end of the Civil War, which were both amended in 1991. But these 2 laws, which are the Civil Rights Act of 1866 and the Civil Rights Act of 1870, they deal with efforts by any individual to treat African Americans differently in the making and enforcing of contracts and in the sale or rental of real estate. So, 5 laws. Who's protected? That's the next question that you ask. What are the laws? Who's protected? The protections extend to different groups of people depending on the law that you look at. The first area, let's look at the Federal Fair Housing Act. There's 7 protected classes, 7 of them. The first 4 came into law in 1968. And I will talk a little bit about the history, but let me just kind of comment on that. If you want to know about the history of the law, I think it's laudable. And I think that we should all focus every now and then on why we're here and how we got here. But I want you as property owners to run a smooth business. And what I mean by that is I want you to treat everybody the same. And the only thing that should matter is whether someone can afford to live in your unit. Period. That's all. And frankly, practicing fair housing is good business. So if I can emphasize those fundamentals to you, rather than going over the history, and I could talk for 3 hours about Jones Alfred H. Mayer, Jones versus Alfred H. Mayer, or Trafficante, or some of the other very important Supreme Court cases that are very entertaining to discuss. But I'm not getting to you the message that you need to hear, which is you need to get a system in place to rent properties. Some of you are here, maybe for the first time, are hearing about fair housing. Some of you are very sophisticated in your approach and are dealing with more finite issues. But all of you need to recognize that fundamental principle. Now, we have 7 protected classes in the Federal Fair Housing Act. Race, obviously, color, national origin, religion. Those are the first 4, 1968. The Act was amended in 1975 to include sex. Now, when I say sex, what do I really mean? I mean gender. Gender discrimination. You can't treat similarly situated men and women differently. Sexual harassment is also prohibited by the Act. Now, in addition, in 1988, we had 2 other protected classes that were added, and they were families with children and persons with disabilities, or handicap as the Act defines it. Shaker's Fair Housing Act is slightly different. It has 8 protected classes in addition to the 7. Ancestry is also a protected class, as is the Ohio Fair Housing Act. The same 8 protected classes apply. The reason I'm telling you this is the first inquiry you should always make if you find yourself on the opposite end of a fair housing complaint, or if you have a question about a fair housing situation, is this person a member of a protected class? Before we even get to whether or not there's been a violation. So let me ask the group. A pregnant woman comes to your unit, and she wants to know if she can, in fact, rent your 1-bedroom apartment. And you, seeing that she's pregnant 8 months after she tells you, says, well, I own this property, I live downstairs, and I don't rent to children, and I see that you're going to have children here. Now, my understanding is, after going to another fair housing seminar, that I'm protected by the Fair Housing Act because there's an exemption. It's called the Mrs. Murphy exemption, and it allows me not only to turn people away who have families with children, but it allows me to actually tell people that I don't rent to children. So I'm sorry, I can't rent to you. Now, how many of you believe that that person is justified in not renting to that pregnant woman? The cameras aren't focusing on you. They're focusing on me. Come on, give me a show of hands, honestly. Okay, I have 2 gentlemen in the back. How many of you aren't sure, honestly? I got a bunch of hands. How many of you say that that's a violation of the law? Okay. Now we're getting into the law. This is a tricky one. Yes, question. Well, I'm going to, if that's okay. If you are the, Mrs. Murphy applies, we'll talk about this, but Mrs. Murphy applies to someone who owns 4 or fewer units and has not engaged in any real estate transactions in the prior year. And what it simply says is, the federal act is that you can turn away families with children if, in fact, you qualify under that exemption. That, in fact, the Fair Housing Act does not apply to you in that situation. And I define the Mrs. Murphy exemption for you. If you would take a look at the questions and answers section, and I'll refer you to the section I'm talking about. It's actually page 21 if you'd like to take a look. And what it says is that according to the Mrs. Murphy exemption, you as the property owner would be permitted to refuse to rent or sell to families with children, provided that you occupy no more than four units, and that, in fact, all the families living in those units are living independently of one another. Now, what I want to talk about, though, is that my first question is that person who's pregnant, is she a family? Is she protected by the law? Who says, no, I'm not sure? Moral considerations aside. Okay, she is protected. A person who is pregnant is protected by all of the laws, federal, state, or local. All right, that's step number one. Because remember, the first question is that person a member of a protected class? She's a member of a protected class, okay? Now, you being that single-family owner, you're feeling pretty good because you're on comfortable ground, that the federal law actually provides this exemption for you. Well, it does. That's right. But did you manage to keep a copy of the state law in your notebook? You know, that notebook that you keep that keeps you informed of all the fair housing developments? Oh, you didn't. Well, you see, the state law does not have a Mrs. Murphy exemption. Shaker Heights does. But you're on the hook anyway. Let's say that the state law and the federal law and the local law, they're all the same. Let's say Mrs. Murphy applies to you and you're exempt, so you think. You know what? You're not. You're still in violation of the law. You know why? Because you can't tell anyone, whether if they're a member of a protected class, that you have a preference for someone else. There's a section of the law that deals with statements that we're going to get into. And my intention in this first 45 minutes is just to indicate to you that there's a lot to learn. But there's a section of the law, 42 U.S.C. section 3604C. I call it the statements section, or advertising. And in that statements section, what it says is that you may not, under any circumstances, indicate a preference, make a statement that indicates a preference, that would, in fact, try to classify a certain group that you would prefer over another, whether or not Mrs. Murphy applies to you. So be careful. If, in fact, someone comes to you and you are covered by the Mrs. Murphy exemption, that still doesn't mean that you are in violation of the Act or not in violation of the Act just because you say Mrs. Murphy applies to me. In fact, you may be in violation of the Act simply because you say no children, no kids. You've indicated a preference. You've classified a certain group that's in a protected class. And that can really trip you up. And that, my friends, is what many fair housing groups are looking for. Because I've worked with a lot of fair housing groups. Go ahead.
I find that very interesting because I've had a lot of people come and ask me, you rent to people who have children. Come right out and answer that question, one of the first things they say.
And I'm curious, what do you say?
I don't give them, I didn't know this was done this way, but I don't give them direct answers because I'm afraid to say anything.
And really, you know what you should say? You should say, I rent to those people who qualify per my non-discriminatory standards, which let me tell you what they are. You know, whether they can pay the rent on time, whether they qualify and they have good credit, and you go down your list. But whether I rent to families with children, you know, that should be irrelevant in the standards that, you know, especially when you get a question. Now, we're going to go to questions and answers in a minute, later on, but it's a very good question. Now, why is it called Mrs. Murphy, just out of curiosity? In 1988, when Congress was deciding, and Mary Murphy, who's on our staff at Shaker Heights Law Department, she always smiles when we talk about Mrs. Murphy. And really, Mary, you don't look anything like I think they envisioned Mrs. Murphy, because Mary's this young, attractive, smart individual. Mrs. Murphy was the person that many Congress people said, well, what about, you know, families with children, a new protected class? Well, what about Mrs. Murphy? You know, little old Mrs. Murphy that's living by herself and wants to rent out the upstairs because, you know, she doesn't have any income. What about little Mrs. Murphy? You know, are we going to allow her to be burdened with all those little pitter-patter of feet above her head when she wants to get to sleep after she's watched Jeopardy? I mean, what are we going to do here? Well, unfortunately, I don't think Congress really thought this one completely through, because as you can tell, this is a real, this is a real tricky area of the law. Mrs. Murphy only applies in certain situations, and even if it does apply, you can never tell someone no kids. Never. Now we're at 10 o'clock, and I promised the members of the law department that I would allow for periodic breaks. So let's take a 10-minute break, and then we're going to really dive into the substantive portions. Okay? Thanks.